No political party challenges either governor's rule or president's rule or dissolution of assembly contemporaneously. Dissolution not challenged at all. Otherwise, your lordships are aware, my lord. Your lordships are disturbed even at the middle of the night that now we are ready to forge an alliance and we are ready to form a stable government. Because there were several arguments were made on that. That how can the assembly be dissolved like that? I am just, my lord, pointing out the hollowness of that argument. But before I go further, I must deal with one submission.
So, writ petition civil 1099 of 2019 did not challenge these three things.
My lord, writ petition is by...
did not challenge the governor's rule, president's rule, or before that?
No, my lord, I must point out. The governor's rule is challenged, but after 14 months, when...
After, in 1099.
5th and 6th of August 2019, when that was... must be being drafted, it must have been advised that you have to challenge the main imposition. That appears to be the case.
So the governor's rule was challenged.
Challenged after 14 months.
Then obviously the president's rule would have been also challenged.
Yes.
It's bound to be.
Yeah, bound to be.
And dissolution of the legislative assembly is also challenged.
Is not challenged.
Is not challenged.
Is not challenged. Still not challenged. In any of the petitions till date.
Till now, none of the petitions it's challenged.
Yes. None of them.
And that's in terms of section 53(2).
Yes. And, my lord, the petition argued by Mr. Sibal, which was which is number 10 loan, Abdul.
That was 10.
Muhammad Abdul loan, my lord, which was by NC, National Conference. Not even president's rule or governor's rule under challenge. Well, I have a list. I have the list, my lord. I'll just show that list, my lord, to your lordships.
To know fact, whether the governor's rule was challenged through a PIL filed in this court, dismissed. There was a PIL filed in this court, challenges government's rule, was dismissed by Justice Gogoi. And I'd be very happy if this court were to say that because all this was not challenged, the entire process that is adopted is constitutional.
When did I argue that?
I'd be very happy if this court were to say that.
My lord, where did my learned friend, my lord, why is he presuming what I am going to argue?
Since you are talking about it.
No, I am talking about it because half an hour of a political kind of an argument was made. How can you dissolve the assembly like this? What are the powers of the governor, etc.?
The bench of this court has said you can't do it.
Correct, but you can't argue it without the challenge.
I have never made a political argument in this court, and your lordship knows about it. Not a single political.
But if there is no challenge, and if you raise a plea that there was the governor should never have dissolved, it becomes a political argument. It's not an argument based to suppress.
Taking your point that Mr. Sibal's writ petition, there was no challenge to president's rule, governor's rules, or the dissolution.
Yes, and dissolution not in challenge in any of the petitions.
That we've got.
So, my lord, that question your lordships need not go into. That's the my lord, respectful submission. And my learned friend is right. So please, if you don't mind.
Paper book 501.7, in fact, their counter affidavit has a listing of all the prayers of all the petitions.
I was going to say that, please allow me. I have prepared a list and placed it, my lord. This is the submission in support of my lord, plea that your lordships need not go. Because substantial time was consumed on this argument. Therefore, my lord, I am laboring this point that it was not necessary. Your lordships have seen the chart. These are the only prayers before your lordship. And that too after 5th and 6th of August 2019, after 14 months. And I have, my lord, also narrated a chart showing the pleadings also.
But we have petitions where everything is challenged except the dissolution of the Legislative Assembly.
No, there are petitions.
There are petitions challenging the imposition of governor's rule, the imposition of president's rule, and but according to no challenge to the dissolution of the Legislative Assembly.
Correct, my lords. But one factual clarification. In some of the petitions, even that the governor's rule is not under challenge. For
there are some petitions where there is.
Yes,
but we'll have to deal with it anyway once it is raised.
To have a challenge to governor's rule.
Governor's rule was challenged in most of these petitions post the president's rule.
All the petitions post the decision. That is why
what Mr. Sibal said, there was an earlier petition filed which was discussed.
Yes, well, that's what, my lord, I have pointed out, my lord, in my summary of submissions, my lord.
If there were no actions on 5th and 6th, we won't be here. We wouldn't have challenged anything. We are challenging the actions under those provisions.
No, let Mr. Sibal.
Just saying.
No, I am also, whenever interrupt, I am just saying, but don't do that. That's why the rejoinder stage is always there. I understand your discomfort, but what can you do? What can I do? Ojo.
I mean, I understand you.
Not PIL. It was not a PIL. I'm sorry, it was not a PIL. My learned friend, my lord, possibly not correctly briefed. It was PDF 250. Take my lord, PDF 250. I have, in my written submissions, my lord, I have done this. One MLA challenge. It was not a PIL. Please see, my lord, the order of this honorable court. This Gagan Bhagat was not a PIL petitioner. He was an MLA. We argue. Anyway, my lord, we learn from my lord, senior, my lord. I will not say anything more than that. I am only arguing a matter, my lord. I have no political.
Therefore, they've not included that prayer in any of these petitions because that has attained finality.
But that's what they came to know when I say in my written submissions. They were not aware of it. They have not mentioned that we have not challenged because it is affirmed by the Supreme Court. I'm sorry, ma'am. The Lordship said that we have heard, we have seen the record, and we dismiss the petition. Therefore, I am not going into the details. Otherwise, my lord, I can show details also. But there are reasons, my lord, why it is not challenged. My lord, when you don't have a case on the floor, you don't challenge it. That's as simple as that. But let's not go into it. Why they have not challenged it? It's definitely not because this petition was filed and dismissed. Because none of the petitioners say that this petition was filed, heard by this court and dismissed, and therefore we are not challenging it. They came to know possibly only when I pointed out in my written submissions. So far, it was not on record. Now, Lord, here, my lord, I must answer one question. Lord, suspension of proviso to Article 3. My lord, that was an argument. There are two arguments. The argument was advanced with a nuance that this was a device to bring certain legislative enactments or certain parliamentary actions by suspending the provisions of the article, the proviso to Article 3, namely the reorganization. Like that was the allegation. Correct, my lord, your lordship recollects that. As a matter of fact, right from the inception of this country, whenever President's rule is imposed, proviso to Article 3 is state. We have studied each and every proclamation issued by the President under Article 356 with regard to each and every state, not Jammu and Kashmir. Proviso to Article 356 is suspended in every case. And please have a look at, my lord, the chart which I have, my lord, placed. As if we did something surreptitiously because some sinister plan was in the mind. This happens right from the inception. The first President rule was in Kerala in 1957. Since then, my lord, we have studied, and my lord, we have the learned AG also has the volume, my lord, if your lordship would like to see that. But I have said so. My lord, in S.R. Bomai, the law laid down, and I will come to that, the law laid down is that the legislature cannot function without council of ministers. When that is the position here, additionally, the legislature was dissolved, but otherwise also, whichever provision of the constitution mentions something to be done by the legislature, that provision is suspended. That's the format to be used, being used from the beginning. 1977 was the first use of 356, 59, I'm sorry, 59. Mr. Nambudripad's government was removed and the President's rule was imposed. That was the first and perhaps the most controversial imposition of President's rule. There also suspension of 3 proviso was there. We have the notification if your lordships would like to see that. The first use of 356. This is the idea. This is the purpose. Whichever constitutional provision says use of some legislative act by way of making law, by way of views, by way of recommendation, those provisions stand suspended during President's rule. It was not with a view to do something which they claim to be a fraud on the Constitution. That's the respectful submission. But once the President's rule is imposed, your lordships are aware Article 356 requires that it needs approval of the Parliament. Both the houses will have to approve it. Now, my lord, during the President's rule, there are certain steps taken, my lord, with a view to infuse confidence amongst the people. My lord, there were situations, my lord, which were alarming situations. Everything won't come on record. My lord. Pulwama happened in February 2019, etc., etc. And the government will have to take certain proactive steps. Now, that first step is 1st of March 2019. Now, this is a well-considered administrative decision-making, keeping in mind several factors: national integrity, sovereignty, security, border issues, internal issues of the particular state, etc., etc. Please see, my lord. Now comes, my lord, an important event. Again, my lord, to ensure that those who are staying in border areas are having a sense of security, social security. 1st July 2019. It is critical to note that on the same day, Jammu and Kashmir Reservation Amendment Act was passed by the Parliament, exercising powers as the legislature of Jammu and Kashmir. Your Lordships have seen Article 256 1B, that when President's rule is there, the Parliament exercises the powers of the legislature. Lord, this enactment was passed. Lord, I have said that this has been the practice and the constitutional convention throughout. Whenever there is a President's rule, the Parliament exercises the power of the legislature as contemplated under Article 356 1B. In all states, Lord, this is I am showing in case of Punjab. Lord, the most important part of any legislative transaction is passing of the budget. Budgets are passed by the Parliament on behalf of the states, acting as a state legislature. Lord, Punjab was divided, bifurcated into Punjab and Haryana. Chandigarh was carved out as union territory, and some part of erstwhile Punjab went in Himachal. These were the four bifurcations, my lord, which took place by Punjab Reorganization Act passed by the Parliament acting as a legislature. So, my lord, it is not uncommon, or it is not something which has happened for the first time, that you can elevate the argument to the level of a constitutional fraud.
But this must be a reorganization act under Article 3.
Yes, I'll come to that, my lord. I'm coming to, because I'm right now, my lord, pointing out that suspension of proviso to Article 3 is not unusual. Whenever provision is suspended and President rule is also imposed, the Parliament acts as a legislature.